There is more than one way to hire a person in Poland, since Polish law offers a wide variety of types of contracts. There are significant differences between them, and the choice is not always risk-free. If you are thinking of hiring individuals in Poland, or are yourself interested in being employed in Poland, watch my guest today, Magdalena Świtajska, advocate and partner in Wardyński & Partners Employment and Global Mobility Practice, who will explain your options. After Magdalena has spoken, I will tell you about the current mood among Polish entrepreneurs. Welcome to the program News from Poland, Business and Law, addressed to foreigners acting as board members in Polish companies, foreign investors in Poland and their foreign advisors.
Hello. Let's start with the most popular, employment contracts. Polish law provides for two basic types of employment contracts, for an indefinite term and for a definite term. Each can be preceded by a separate contract for a trial term. The duration of a trial term employment contract cannot exceed 3 months, and it can be used between the same parties only once, unless there was at least 3-year gap between the contracts or the job type has changed. Definite term employment contracts are also limited. Currently, the maximum duration of employment on a definite term contract is 33 months, and the maximum number of contracts between the same parties is 3, regardless of breaks between consecutive contracts. There are some exceptions from these limitations, which apply to specific cases, such as substituting for absent employees, seasonal work, or a term of office on a management board. The main difference between a definite term or trial term contract and an indefinite term employment contract is in the rules for terminating these contracts. Termination of a contract for an indefinite term requires detailed reason justifying termination, while with the other contracts it is not necessary. This, in other words, means that terminating an indefinite term employment contract is not easy. An indefinite term employment contract is also regarded as more prestigious and showing more trust in the employee on the part of the employer. This is the reason why higher-level employees, managerial staff, directors and management board members almost always choose or insist on an indefinite-term contract. Apart from employment contracts, there is also a choice of civil law contracts available under Polish law. Civil law contracts include, for example, contracts of mandate, which are usually used for regular staff. They also include managerial contracts used for board members and for executive and general directors. Civil law contracts also cover all types of B2B contracts used when the individual providing work is registered as a sole trader and conducts individual business activity. There are many differences between employment and civil law contracts. Primarily, civil law contracts do not fall under the employment law regime, meaning that the employment code and other employment laws do not apply to persons hired under such contracts. Because of this, civil law contracts are often perceived as more flexible than employment contracts, and indeed they are. Unlike in the case of employment contracts, civil law contracts have no limitations on working time. They also include no mandatory benefits or leave. The parties to a civil law contract are free to set and decide these terms. The employer is also released from a number of duties in relation to persons hired under civil law contracts that normally relate to employees, such as maintaining personal files or fulfilling certain health and safety obligations. Unlike in the case of employment contracts, a termination of a civil law contract must, in general, comply only with the requirements the parties have agreed in the contract. There are also differences in social insurance contributions and taxes to the advantage of civil law contracts, especially B2B contracts. Therefore, flexibility is a factor that makes civil law contracts attractive in Poland, in particular for employers. But there is a catch. The parties are not entirely free to decide the type of contract or to choose between an employment and a civil law contract. Civil law contracts can be used only for persons whose manner and conditions of work are not typical of an employment relationship, meaning that these persons are not directly supervised by the employer and have the freedom to decide how, when, and where they perform work. If there is supervision over the individual's work and the individual is required to work fixed hours in a designated place in accordance with given instructions, a civil law contract is certainly not the right choice. and making the wrong choice in such a case may cost an employer a fine. Due to the nature of their roles, general or executive directors, board members, and persons performing freelance jobs, for example designers, are those individuals who can benefit from civil law contracts almost risk-free. With other individuals, some analysis and caution is always needed. Thank you for your attention.
For the third quarter in a row, the Polish economy, benefiting from the post-pandemic recovery, is growing rapidly at a pace that is clearly higher than before the pandemic. Businesses' manufacturing capacities are currently at full stretch. High margins and large sale volumes are ensuring that businesses are remaining highly profitable. But despite the very good financial results, business people are viewing the current situation as fraught with multiple risks. First of all, costs of inputs and raw materials are rising and are coupled with problems of availability. Secondly, the strong growth of the economy is causing labor shortages and rising wages. This is increasing production costs, especially in companies with a high proportion of manual labor. Thirdly, export-oriented companies are facing increased uncertainty due to the rising costs of freight. The fourth source of unease present in all sectors of the economy is the surge in energy prices, especially of gas. The fifth factor is the pandemic, which is forcing employers to have to deal with excluding COVID-infected workers from their workplace and placing them under quarantine. Thank you for watching this episode. See you soon.